इसको कहीं चाय लगाओ ना, ये पर तो होगा। काहे इतने हाथ करते हैं?
You're like doing the most vacation. Yeah, complex case. Totally fine. We are also still grappling with it.
सर मनोहर
No. No, I think your body language is different from us, so we cannot park you. You all are from Bombay.
Yes.
Yep. Myself from Delhi. Because we are here Yeah. Yeah, we need to. Thanks so much. Yeah, we can social. Thanks so much. You have got the tumbler. So he is practicing in competition. You're going to
फिर भी आएगा ना, आप पैसे लेके जाना।
अच्छा है मेरे को
हाँ चेक करो हाँ
Yes, yes.
हाँ जी
More scores. We need 6 more scores.
Whatever you will tell them, absolutely.
Greetings everyone. I'm Tushar, the head of sponsorship committee for Mediation Bombay 6.0, and on behalf of the entire organizing committee, it is my pleasure to welcome you all to the final round of Mediation Bombay International Dispute Resolution Competition. Over the past 2 years, we have witnessed exceptional advocacy, thoughtful negotiation, and a remarkable commitment to the principles of mediation from all participating teams and mediators. The journey has now brought us to the final round, where 3 outstanding teams will present their skills before an esteemed panel of judges. We are truly honored to have with us a distinguished panel of experts who bring immense experience and insight to the field of commercial dispute resolution. Firstly, we would like to introduce Ms. Sangeeta Mehrotra, who will be the judge as well as mediator for the final round. Sangeeta ma'am is an internationally accredited mediator and seasoned legal professional with over 4 decades of experience. Since 2011, she has successfully conducted more than 1,000 mediations covering financial, property, commercial, and marital disputes. She serves as a mediator with the Supreme Court of India, the Delhi High Court's Samadhan Center, and SAMA, and is empaneled with leading ADR institutions including ADR Udiyar International, Markyum, Court, Just Act, Camp, and many more. As the founder of Sankalp, Aao Baat Karo, she continues to advance dialogue and mediation at the grassroots level. Known for her clarity, empathy, and effective approach, she helps parties reach sustainable solutions. We thank you for being present here today, ma'am. Now, introducing one of the esteemed judges on panel, Ms. Harshita Srivastava, who is a partner at Shardul Amarchand Mahilas & Co. Harshita ma'am, with over 16 years of distinguished experience, is a seasoned practitioner specializing in private equity investment, exits, and mergers and acquisitions. Ma'am was a member of the SEBI committee instituted in 2018 for the setup of the Innovative Growth Platform in India. For her contributions to the legal profession, ma'am has been recognized by many international publications such as the Legal 500 Asia Pacific in 2023 and 2025, AFP India 2025, and by the Startup Europe India Network in 2019. She is also ranked amongst the top deal makers of Asia in 2025 by the Asian Legal Business. Moving on, we'd like to introduce Mr. Purazar Pozdar, sir, partner at NZM Legal Disputes. Sir is a legal professional with over 16 years of experience in commercial litigation, focusing on corporate civil disputes. He is recognized for handling complex commercial disputes including arbitration, civil suits, and writ petitions. Currently, he is expanding his practice into real estate and technology law, including advisory services in blockchain and cryptocurrency. Sir's extensive experience in commercial litigation, combined with his proven leadership ability, brings significant value to the panel today. At this point, I'd like to hand over the rest to Ms. Zoha Hassan.
Thank you, Tushar. Good evening, everyone. I am Zoha Hassan, head of the Judges Committee. It is my privilege to introduce the remaining members of a distinguished panel of judges. Firstly, Ms. Sudeshna Guha Roy, who is a partner at Saraf & Partners. She has an extensive experience of nearly 17 years addressing litigious mandates across several sectors relating to shareholder disputes, deadlock in management, foreign investor exits from the portfolio companies, etc. She was recognized in litigation star for commercial and transactions by Benchmark Litigation in its Asia Pacific ranking of 2025. She was also recognized as a recommended lawyer for dispute resolution practice by the Legal 500 in its Asia Pacific ranking of 2023. Introducing our next panelist is Ms. Meeta Kurbal, who is a partner at Cyril Amarchand Mangalas. Ma'am has an experience of 11 years in the banking and finance practice and specializes in structured finance, project finance, receivables and asset-backed financing, cross-border financing, stressed debt transactions, and asset reconstruction. She has advised a consortium of 22 banks and financial institutions led by ICICI Bank Limited in structuring and implementing a debt resolution plan for Jayaprakash Power Ventures Limited. She has also advised Reliance Industries Limited and its subsidiaries in one of the largest and first of its kind monetization structures with business receivables from office parks with securitized through structured debt. Introducing our next panelist, Mr. J.P. Singh, who is a senior advocate at Supreme Court. He is a well-known civil, commercial, and arbitration lawyer and has appeared in diverse cases, including challenges to constitutional validity of various statutes. He has represented several public sector undertakings like State Trading Corporation and National Textile Corporation. He was also panel counsel for Government of Institute of Delhi and on the senior panel of Union of India. Mr. J.P. Singh has meticulously pioneered the mediation movement in India and worked tirelessly to spread awareness and build the capacity of trained mediators in various spheres all over the country. He was also appointed founder, organizing secretary of the Delhi High Court Mediation and Conciliation Center, Samadhan. He has been appointed as mediator by the Supreme Court of India, Delhi High Court, and various courts in several conflict disputes. He is an accredited mediator by Cross Institute USA. He was also a member of the panel constituted by the Honorable Supreme Court of India for drafting and recommending legislation on mediation. We are extremely grateful to all our judges for joining us today and for contributing their time, experience, and insight to the competition. Before we begin the round, I'll briefly explain the structure and timing for the final round. The participants have already been given the confidential information, and now the main negotiation session will stand for 90 minutes, which will be followed by a reflection session spanning over 10 minutes. I request everyone in the audience, please put their phones on silent. With that, we'll now, if the judges so allow, proceed with the final round of the Mediation Bombay International Mediation Competition 6.0. Best of luck to all the teams. Thank you. Yes.
Thank you all for being here. Welcome to Bombay Mediation Center. I'm Sangeeta Vedopra, your mediator. You can call me Sangeeta. And I think I've been told that I can take the names of the companies who are sitting in front of me. I sincerely appreciate your choosing mediation over and any other dispute resolution process to reach a resolution. Please be relaxed. I will make this whole process as comfortable for you as much as I can. If there is any point of time you are not feeling comfortable, I will listen to you alone, separately. I hope you have the authority to take part in this mediation and also sign the agreement to mediate. Okay. Let me tell you, mediation, mediation is a voluntary process, not binding to the point of agreement and without prejudice. Also, it is private and confidential, and you need to sign the confidentiality agreement before we start the process. As I said, everything said in this room shall remain confidential. Nobody can refer to or use the offers, counter-offers, concessions, admissions made during this mediation before any public forum, including court or arbitration. Nor I can be called as a witness or speak on behalf of either of you before a court or an arbitrator. My role as mediator is only to facilitate the dialogue between you and to help you create options so that we reach a consensus as partners to this process. Here I am not a judge or an arbitrator. Let me disclose that I have no personal interest in the outcome whatsoever. As mediator, I will be neutral. I hope I made myself clear. Although I do not control the outcome of this mediation, I control the process. So let me, it's something. Although I do not control the outcome of this mediation, I control the process. It's very clear. I control the process, so let me put before you the ground rules. One speaker at a time, please. Focus on solutions, not accusations. Confidentiality of mediation discussions. I may pause discussions or move to private sessions whenever needed. You will talk through me for voicing your concern. And do not use cell phones in this room. Do I have an agreement on these?
Yes, Madam.
Okay. We will start with a joint session now, and then I will most likely meet each of you at least once in private and want to hear from you any additional things you prefer me to know that you do not want to share with other parties. Any doubts or questions? Okay, I have been provided with a fact sheet comprising 10 exhibits, that is the general information which you all have been given, I think, which offers a comprehensive overview of the dispute presently before this mediation. And for optimum use of the 90 minutes given for this session, we will set the agendas as quickly as possible. Before we begin, may I confirm that each party is here with the intention of exploring solutions that protect both regulatory integrity and investor stability. And would everyone be comfortable if we focus today not on assigning responsibility, but on identifying walkable pathways forward? Good. We have 50 participants, I am telling you, in the room along with their counsels. The dispute involves MNT Energy, representing RIT Corporation Block, the Global Institutional Investment Fund, GIIF, and the Securities and Exchange Compliance Commission, SECC. And I would like you to come up with your statements in that order. So first, I will ask MNT to come up with your.
Thank you so much, mediators and details, for setting up the ground rules for our mediation session and also to help us allow us to understand the mediation process earlier. Good afternoon and happy to meet everyone here today. My name is Jordan Myers and I'm the Chief Executive Officer of MNT Energy and I am representing RIB Block today. Feel free to address me as Jordan and you may hear me refer to my company as MNT and my block as my block. Today I am joined here with my legal counsel, Kavi, and I would like to start by sharing my opening statement and the concerns that I have moving forward. I would also like to first extend my thanks to Tyler and his counsel, as well as Morgan and his counsel and Tyler and his counsel here today from GIIF and SECC. I understand that the current regulatory and geopolitical environment has brought about great vitality within the markets, and I'm heartened that we are all here today to discuss how we can better support one another moving forward in terms of supporting one another in this unstable situation. Now, collectively, my block generates 25% of RIB's total energy outputs and nearly 4.8 billion USD to the national GDP annually. Together, we are 9 companies who hold 22 to 25 billion USD across the 3 exchanges in SECC, and we have a huge global investor base as well who have put their confidence in us. The Southern National Security and Strategic Info Protection Act, which I'll call the Act for short, has come to a shock to us because it prohibits us from presenting our audits to international governments. Otherwise, we would face significant financial penalty. Now, together with our freezing of our trades, this is a significant financial interest that we have to protect because our stocks have plummeted overnight following these regulations. Hence, we come to the table today to find a path forward with USECC so that we can transition together with stability and also to protect our investors' confidence in us. At the same time, GIIF, I recognize that we have a relational interest with you, and thank you for putting your trust in our stocks thus far. Now, our investors have placed their trust in us, and we will do our best to give them the assurance that they need in today's session. Hence, we also hope to find a way forward with you to build our confidence together and also move past this difficulty and also continue our relationship for years to come. Taken together, my block's interest today is operational stability, and I see a future where we can tide through this if we come to a resolution today. So I hope we can set aside our differences and find out how we can best support one another through this volatile situation. That's all from my side, and I'll hand over the time to my legal counsel, who will elaborate on the agenda points we have in mind to make the most out of today's session. Kavi, please.
Thank you, Jordan. Good afternoon, everyone. My name is Kavi Perna, but you may address me as Kavi. I am the legal counsel for MNT. Now, thank you to SECC and to GIIF for coming down to today's mediation session, because your presence here signals our commitment towards a successful session together. Before I continue, I would like to emphasize that I am here solely in an advisory capacity. I do not have the authority to make any decisions on Jordan's behalf. And I'm here to advise Jordan and to keep a foot on the legality of issues that are discussed today. Now, I have advised Jordan here on operational sustainability of the RIB corporate bloc in SECC countries, which will mainly require the commitment of us working together with SECC and GIIF. Now, Jordan here does recognize the gravity of the current situation at hand and the potential ramifications if we are able to resolve the matter in a timely manner. As such, Jordan is here to collaborate with you all to develop a constructive path forward together. Now, MNT's main concern coming into today's session is with regards to, first, an operational concern about the Ribbon Energy Enterprises and how we are able to protect the business and financial stability of the river companies in the bloc. And secondly, with regard to the relational concerns and how we are able to assure our investors in the future. As such, I would like to propose the following agenda points for MNT in today's discussion. This would be overarching idea of the delisting shares of the RIB corporate bloc in SECC countries. And this would be with regards to, first, a fixed timeline, and secondly, a fee arrangement. With that, I pass the time back to the mediator.
Thank you for being precise, and precisely both of you will keep that timeline. I think it is 5 to 7 minutes. Yeah. 1 minute. So now I call upon GIA.
Thank you, Madam Mediator. I hope I'm perfectly audible.
Yeah.
Thank you, Madam Mediator, for walking us through the process. I think you have beautifully explained the importance of mediation, and I can assure you that we come here seeking solutions to protect our investors. That is our primary goal. Of course, thank you so much to the representatives of the SECC for agreeing to participate in this mediation. And thanks a lot, Jordan and Kami, for outlining the position, the problems that all of us are facing as investors. I represent, my name is, of course, Morgan today, and I am Chief Representative of GIIF. This is the Global Institutional Investors Forum. This is a coalition of major institutional investors, including pension funds, sovereign wealth funds, insurance funds, asset managers, etc. GIIF collectively holds 7.8 billion worth of securities that currently stand frozen in these three jurisdictions. This amounts to roughly 38% of the total publicly traded shares across these three exchanges, just to give a highlight of the gravity of the problem the investors face. I do not want to comment politically on the state of the situation, whether the government of RIP is right or wrong, but we believe that countries independently have a sovereign right to impose sanctions. But what we also believe very strongly is that first, SECC holds a fiduciary duty to protect investors, and second, MNT and all other 8 companies in the bloc hold legal duty to protect the interests of shareholders. We don't want you to lose sight of these investors. It is these investors and shareholders who we represent today. Just to paint a picture, we do not represent just some big hedge funds or some private equity firms today, but also many retail investors who do not have the kind of same exposure. Imagine a 70-year-old couple with all life earnings in a pension fund, a healthcare patient, all money invested in an insurance scheme. Millions of retail investors who do not understand what technicals and fundamentals mean, and their money is all stuck in it. The imposition of sanctions and the proposed delisting has caused 2 major problems that I would like you to take note of. First is the erosion of market value, because the stock prices absolutely crashed when these announcements came. And second, it led to illiquidity in the market. So these retail investors cannot exit the market even if they want to right now. Our goal is to ensure that investor interests are protected and we don't lose sight of that. For that, we want you to give sufficient time to investors to move out before delisting happens. And second, more importantly, that there is some financial cushioning for these investors. Just to put it in numbers, there is a loss expected of up upwards of $800 million to these investors if this process goes ahead. So we want some kind of financial cushioning. We hope to resolve this amicably and move ahead in the spirit of solutions. I will quickly hand it over now to Jen, who is an external counsel and also a good friend of ours.
Thank you, Morgan. I hope that I'm audible as well. At the outset, I would like to thank both parties, MNT Energy as well as SECC, for joining us in this mediation, as well as, of course, Madam Mediator. I think you've explained the process in a way that has really put the parties at ease. As mentioned, my name is Shruti Jain. Please feel free to refer to me by my first name, Shruti. I'm the legal counsel for GIIF. And I've been practicing for over 10 years. I have expertise in shareholder rights and investor protection. So please rest assured that I do have sufficient context about this industry, and I accordingly hope to be able to contribute in meaningful ways. That being said, my role here is that of an advisory capacity. Of course, I will address any legal points that may come up, but I hope that you all remember that this is a mediation session. I also echo the importance of confidentiality as mentioned by Madam Mediator. That is, of course, something that is very important to us as well, and I hope that makes for a more open and honest discussion between all of us here today. I would also like to reiterate that Morgan does have the authority on behalf of the investors to communicate all concerns and expectations, and also make and accept offers on their behalf here today. To now briefly highlight the interests of GIIF today, it is of course primarily to ensure that investor protection mechanisms are in place. Firstly, this means ensuring that the de-risking process is gradual, and it is also secondly to ensure that investors get some monetary relief in the form of buybacks. Thank you so much.
I hope I'm audible. Yeah, greetings everyone. I am Tyler Frank and I am the presiding chairperson of SECC. Thank you so much, Madam Mediator, for so beautifully explaining the process of mediation. I believe the way you explained it really put to rest all the doubts we had about potential hostility, and addressing our concerns one-on-one. That is something which we really appreciate. Just to give some context on SECC, so we're the Stock Exchange Coordination Committee. I would just like to reiterate that we aren't a singular entity here. The SECC is a combined effort created by a joint MOU signed by three different countries. Three countries who have their own individual stock exchanges, own domestic laws, which are just for the purpose of coherence. The continental state of Atlantis, the AU Union, and the Greater Islands. While I appreciate the concerns laid out by MND as well as GIIF, I see how investors the investors and their interests are something which we need to protect, and we do agree. That is something which we really concur with. Additionally, talking about your financial interest and your share market taking a hit. That are all things which we have already taken into consideration. All that being said, I'm happy to tell you that due to a meeting which took place between all three countries, the SECC has been authorized by all three of them to reach a settlement on all three of their behalf, which means I do hold capacity to settle and reach an amicable settlement for the parties. To explain our situation better, while generally a compliance authority comes across as a strict enforcer standing in front of everyone, just with the rule book, hey, comply with these. That is not our intention. That is not what we are coming from. Compliance is something which is not only a hard and fast rule with us, it's about dealing with reality. To us, we believe that we come here bearing the torch not only for the countries but for the large amount of citizens, the investors like yourself who participate in the stock market. We are aware of the current situation, the fact that sanctions have been imposed and investments have been freezed. And as has been said, that while we shall not try to and we shall refrain from commenting on whether the law created by the government of MND or in the country of MND is correct or not, that is certainly a pressing concern for us. Compliance is something which we and I think my counsel will concur with me, hold of utmost importance. And again, having said all that, we do not come here with the spirit of assigning anything. We do not come here with the spirit of, just, fining and, putting some compliance on some people. We come here with an amicable spirit, with the, spirit of settling. And as my counsel Vivek always tells me, that mediation is something that cannot take place with closed fists. It's something that happens with open hands. So we come here with open hands for a handshake and maintaining that spirit. Over to you.
Hope I'm audible. Greetings everyone. I'm Vivek Sharma and I'm the legal representative of SECC. I'm grateful to be present here and I thank GIF and MNLU to be present here. I'll be presenting in a totally advisory capacity, whether it's decision-making capacity, press with Tyler. We'll be representing AU Union, Continental States of Atlantis, and Greater Ireland. We shall be discussing the prospects of listing and delisting, but before that, I'd like to say that we'll be truly abiding by the principles of confidentiality and harmonious cooperation. Also stating that during the session we shall be taking notes, but we shall be destroying those notes after the session for the purpose that nothing goes out of the session. Moreover, I request the dear parties to actually share the relevant information at the relevant time so that it becomes easier for us to coordinate and cooperate. Moving ahead, as I already stated, that we shall be discussing the prospects of listing and delisting, the nature of compliance. As Tyler stated, that we are not here to challenge any country's sovereign decision or the important national policy, but to address the larger concerns revolving around transparency and audits, as is also a general principle in the contemporary times. However, we do find that the National Security and Strategic Information Protection Act of RIV is somewhat problematic, but we shall be dealing with that. And there has also been a conflict of regulatory requirement. However, we will be acting in a way that will be appropriate and suitable for all. Including this, I shall be moving ahead with the points of interest. Firstly, discussions on compliance with the SEC standards and the 3 nation mandates, also exploring delisting timelines. Second, discussing potential solutions around the current sanctions condition, precedent being amicable settlement. And rest here.
Okay, I will ask SECC, what I understand that you are balancing market integrity with rules that limit your flexibility. Right? So, from the regulatory side, what legal or systemic risks require your immediate attention?
Thank you. I'm out. Thank you.
Can I repeat the question?
No, with regards to the pressing legal concerns which we currently face as the SECC, is firstly the delisting, which is the biggest priority here. So the country of Atlantis has already released a circular which we have as the exhibit as well, which clearly talks about how there are potential sanctions which they wish to impose on auditors who come from the country of RIV or some foreign jurisdictions who do not agree with them, who do not subject themselves to audit. So that becomes a very pressing security concern for us. The other countries as well, which we bring to the table with us as stakeholders, have pressing concerns. So while we wholeheartedly understand that for MLT and perhaps GIF, delisting or other sanctions become a very tough thing to deal with, that is something which is unavoidable for us to some extent. So answering your question, these are the pressing concerns which we have. But of course, we come here in good faith and are open to discussing what potential timeline relaxations perhaps we can discuss with regards to delisting. If that makes sense.
One more query. What responsibilities towards domestic markets and investors are guiding your decisions here?
Thank you. So, Madam Mediator, I think that is as we already stated, domestic investors, people who have invested in securities, including index funds, mutual funds, pension schemes, especially, are a very pressing concern for us. As rightfully stated by Morgan, my counterpart here, we do certainly own a fiduciary duty to, the domestic investors we have, and we come here in a spirit to ensure that any delisting timelines that are present are, to our best capability, flexible towards them.
Okay, now I go to MNT. From your perspective, what is the most important thing the regulators and investors in this room should understand about the constraints created by RI's legislation?
Thank you, Madam Mediator. I believe that I hope to emphasize that currently the position we are in is that we are facing a hard regulation that is imposed by our government. What this entails for us are two things. First of all, we are unable to provide the audits to foreign governments, and we understand that this is important to SECC, especially in compliance with the international trade regulations. However, if we fail to abide by this, what we are facing is significant financial sanctions by our government. And this is against the backdrop of our current financial instability following the drop of our markets in the SECC currently. So therefore today, our finances are at stake. And this is something that I hope to emphasize at the table today, because our finances are very tight at the moment. That said, we also want to protect the relational interests we have with our investors, and we understand that the investors have put their confidence in us, and we want to address them here today. Earlier, I heard from GIIF as well that they would like for a transitional timeline, and I heard that SECC is open to this idea as well. And I'm actually very heartened to hear that, because that's also what we are looking for towards the delisting process if we are able to comply with the international regulations that I understand are very important to you at SECC. So, Madam Mediator, that is what we come here today. We face financial interests that we have to protect and a relational interest with our investors that we also must protect today. And therefore, we want to work with SECC for a timeline that is feasible, that also protects our finances, and to GIIF to reassure them on their investments with us.
Thank you. GIIF. The central concern is not simply price decline, but being locked into positions without a functioning market. Right. So could you please elaborate from the standpoint of global institutional investors, what concerns are most critical at this stage?
And in 2 points, there is illiquidity A and lack of exit mechanisms B. Right? Illiquidity is basically that there is no buyer. These are retail investors, these are pension funds hosting money of retail investors who are unable to exit. As I said, these are not hedge funds who can take these losses, but retail investors. So illiquidity is the first thing, because of which we would want to explore delaying the delisting and having some kind of exit mechanisms, which of course SECC and MNT will have to work together to facilitate. And the second is of course the issue of disruption in value. So we are facing a lot of stock market has entirely crashed because of these announcements. As soon as the delay is in place, market will gain some kind of volatility. There will be some, because of which hopefully prices will rise, but they will be insufficient to compensate the losses which these people are facing. As I said, there is an estimate of $800 million which will be lost. We propose that this can be countered either by a buyback mechanism, which MNT or other shareholders or other companies initiate, or some kind of compensatory arrangement.
Okay, so the positions here is clear: audit transparency versus national security restrictions, investor protection and liquidity, regulatory compliance pathways. If I have correctly understood that the core concern for MNT is the legal impossibility of sharing audit materials under RID law. They have to prescribe national law. Is it fair to say that investors are primarily worried about liquidity and value erosion?
Absolutely.
From SECC's perspective, the key issue is maintaining inspection standards required by your regulatory framework. Is that So it appears the issues cluster around 4 areas: trading suspension and liquidity, regulatory compliance and audit inspection, investor losses and market confidence. These are the 3. And the 4th issue is the possible pathways to restore trading. So would you, the parties I am asking, that could we go ahead to find out this possible pathways? Are you agreeing to that? Does it capture these, whatever I said, capture the key concerns, or would you like to add to this list? I know you have talked about buyback. I'm not touching it right now.
I think we can include it in the 3rd point that you mentioned, which is investor losses. Because buyback is just one of the suggestions to minimize investor losses. So
Buyback for MNT, no? They are also having, you are telling buyback for who will be buying that?
MNT and other share and other companies will be buying
That
back.
is the RIT law.
Correct.
Yes.
They will be buying back to induce some kind of liquidity.
I think after this announcement and all that, share market must have collapsed.
Yes.
So, double value for that.
Correct. So the buyback will be hopefully at a price which is fair. That is another concern that will come on the table, but I'm hoping that once we delve deeper into it, we can install those safeguards.
So, setting the agendas.
Madam Mediator, I just wanted to check because I do understand that GIF, SECC, and NNG, we actually did raise the possibility of a delisting timeline. So I just wanted to confirm whether this timeline is something that was included in the agenda, in any of the points that were mentioned in your agenda.
Yes, definitely.
Madam Mediator, if we may, could we seek some more clarification when we talk about exploring potential pathways? Of course, as a regulatory.
Okay. Is there a compliance pathway that respects RIB's national security restrictions while satisfying foreign regulatory inspection requirements? Is it possible? Balancing the two.
Madam Mediator, that sort of concern, that is exactly the sort of concern that SECC comes to the table.
So how would we, like, this is a joint session, we can come up with your, what you say, the feedback. How would you like to go ahead with it?
So, Madam Mediator, if we may, I think with regards to RIB's, potential compliance with the domestic law, balancing it with SECC compliance, if you deem appropriate, we believe that we would like to, seek some clarifications from MNT Energy and the RIB block as well with regards to, what is the actual pressure from their domestic, authorities, and what is the compliance framework, if any, they have explored for SECC, if I may direct that question.
Yes, Madam Mediator, if you could help us understand your question and summarize what you have earlier mentioned to better understand.
You are saying about the balancing the two, the national restrictions and the sanctions being imposed. So what are the path ahead? If you can give us some bullet points on that, so that we can, because the paucity of time, we cannot go ahead with questioning and getting the answers and all that.
Madam Mediator, if I could just step in, I believe the Number 3 Act itself, Section 42(2) allows you to obtain authorization from the government. So, are there any communications you have had with the government so far regarding that?
Thank you for the question, Madam Mediator. If you may, firstly answering the question which you asked us with regards to compliance pathways. Before exploring what potential, giving some bullet points with regards to how they can, comply, we would like to seek, potentially more clarification about the domestic context of these laws. If MNT has had some conversation with their domestic government, if they have had some communications internally with them, and answering with respect to that, there has been no communication with us, at least with regards to RIB's domestic law, while we believe that this domestic law, as you also said, we are not technically here to question, if is it right or wrong. We do respect TRIP's right to, create domestic law and their sovereignty. However, there has been no communication by the SECC specifically with the government of India with the last.
Is it right to say that it seems everyone shares an interest in avoiding sudden market disruptions while respecting legal constraints? That is the overall mistake, all three of them. So can we go about a temporary compliance bridge, if you can say?
Yes. Thank you, Madam Mediator, for raising that. And also, earlier SECC question for more clarification about our communications with the government on the regulations. Perhaps to shed more light on the situation, as I've answered earlier, I believe that the regulations are hard imposition to us, and we are unable to work around this particular regulation without having heavy financial penalties. But that said, that does not mean that NMT has not tried, because we understand these regulations pose a significant risk to our overseas markets. So what we have done as MNT and my blog is we did raise this to the government, and we did try to test against this particular regulations, because we understand that it's really a difficult position that all of us are in. Now, to shed more light, the government has granted us a leeway for us to work on, as what Madam Mediator mentioned, a temporary way forward with regards to maybe the listing that we were all talking about earlier. And this, for more context, is we were given a timeline of 36 months. And what this means, and I believe for GIIF as well, is for the investors to exit the market within this period of time. And SECC, I will need your cooperation on this to discuss whether we are able to have a leeway for a phased delistment so that we can protect our financial interests and also, I believe, GIIF's investor interest in exiting the market. And on this note, I will leave it to Kavi, who has her legal expertise to share on this matter.
Thank you, Jordan. So with respect to National Security and Strategic Information Protection Act, specifically with regards to sections 42 and 43, what my blog and specifically NNT has managed to lobby with the government was this emergency ordinance, whether it be a temporary suspension of the strict application of these two sections, which actually restrict us from sharing any protected audit information with any foreign entity. So actually what my client here is most interested in would be with regards to the delisting process, because we have been granted a strict transition period of 36 months. And right after this transition period has elapsed, our blog will be required to comply fully with the government with respect to clauses 42 and 43 of the Act.
So SECC, what transitional mechanisms like scope for temporary trading arrangements or phased implementation of trading prohibitions are legally permissible within your current regulatory framework? Is it possible? If I may say, could the exchanges allow a limited trading window for investors to exit before any prohibition takes effect?
Indeed, Madam Mediator, I believe that we are eligible to that. And as Sam also told me that if he is able to actually frame a temporary compliance mechanism, that would be great. Because ultimately, if we have to head towards delisting, we all know that it is not something very positive. But certainly, if we go towards that prospect as well, we have something with us, a draft with us to actually solve this.
So giving more context on what Vivek just said. So we're really happy that, as a block, we understand you must have certain amount of bargaining power with regards to with your government. And I believe you must have used that, which I'm very happy to see, to actually get some, breathing room from them. So I think that actually will help us to talk about compliance. So perhaps you talk about 36 months as a delisting timeline. So we also have a delisting timeline with us, but the delisting timeline we have is a little bit different. Before I quote the exact number, Madam Mediator, we must provide some context on what kind of a delisting timeline we're looking at and why is it. So I think that would bring us to GIIF. So we understand that you guys have a large amount of investors, people who really need some breathing room to potentially exit, explore pathways, and we talked about illiquidity as well. So to us, what it seems is that 36 months, while we have agreed that delisting is something which can has to take place, but 36 months for that is, I believe, something which is very difficult, and I think GIF would also not be very happy with it, if I am right. So what we propose is a total of 44 to 45 months as a delisting timeline, and perhaps if GIF would like to clarify more, we can talk about the exact structure of this compliance roadmap, of this delisting roadmap. My apologies.
Thank you, Tyler. I think that gives us a lot of headway because you've in fact proposed an increase in the delisting window, which I believe if I like to understand, delisting will only begin after 44 months. That gives investors 44 months to trade. I think even M&T would be favorable to such an arrangement. I just want to understand your position.
Definitely. Actually, Kavya, I think we do realize that we have 36 months. So I just wanted to find out and whether you could share with SECC and GRIF what is your concern with perhaps having a 42 to 44 months compliance period, transition period.
Yeah, thank you so much. And
Would it be a structured delisting or over the period of whatever 45 or 50?
Right, Madam Mediator. So I hear from SECC that they propose a total timeline. Now, we are unable to work beyond 36 months, first of all, in terms of the total timeline, because that's what we managed to get from our governments. And beyond that, we are looking for, as what Madam Mediator suggested, a structured timeline where we have the exit of 3 companies at one time. So what this looks like for us is a phased transition for the delistments. So to answer GIF, your question earlier, when you asked about whether we are having the delistment after the 44 to 45 months proposed to SECC, I have 2 responses to that. The first is that we are not open to a 44 to 45 months, as I've mentioned, because the 36 months is the upper limit that we have managed to bargain with our governments. And unfortunately, this is the difficult position that we are in. But we understand your interest in terms of having the investors exit. And I also mentioned that you also mentioned that you wanted the investors to exit slowly. So what we can propose, and perhaps this may also meet your interest in terms of allowing your investors safety, is we could have 3 companies delist in a period of 7 months, and another 3 companies to delist in the next 7 months, and the last 3 companies of our block to delist in 7 months. The period here that we're looking at is 21 months, and I understand SECC raised 44 to 45 months. I would like to explain my reason for why I suggested this particular 21 months totality. And that's because, first of all, we also need to balance the financial interest that we have. And time over here is of essence because we need to also find ways to mitigate our current markets and go into new markets as well. That is why we are hoping to also find leeway and breathing room within these 36 months rather than maximizing it so that we can also move and also prioritize our operational stability, which I believe SECC has mentioned that they want to balance both operational stability, market stability, and investors' confidence as well.
Yes.
So, clarification here. I'm finding it difficult to understand as to why this MNT want a shorter window of delisting.
So what about this kind of a structured exit window for investors address liquidity concerns? That is more important.
And structure is I think important and that's good, but I'm pushing for a longer window before delisting starts. Now I will just a bit confused as to what the positions and interests
Just elaborate on this.
Exactly.
Why exactly?
So we as investors want a larger period before which delisting starts. Right? Delisting is basically when you pull down your company from the stock market. So my assumption was that M&T as a company would want longer time in the stock market so that trading goes on by the time they try to resolve their issues with their own government, with the SECC.
Exactly.
And
if they exit also, there will be that exit window.
Correct. So in a longer term, which is around 40 months, if they're able to structure it in a phased manner, which is let's say 3 companies in 12 months, 3 companies in 12 months, in fact it will be 14 months, 14, that will be important. And one more thing that I was highlighting to protect the shareholders' interest, and I think Shruti can add if there's anything, that we want to ensure that in this timeline, there is adequate demand for these shares. Because today the investors are willing to sell, but what if there is no demand?
Yes.
That is why we were initially proposing a buyback. If not buyback, we want to inquire if there are any investors that you know, any institutional investors that you know, or
You all think about, have you thought about depository receipts or something like that?
Madam Mediator, I think that is, we can take that question. First of all, I believe there was some confusion when we mentioned the 44 to 45 month period. That is also phased compliance. We are not saying that delisting will begin after 45 months. And I think we also concur, we were also thinking that perhaps MNT would also be looking at, a longer time period. And I think for perspective, why the longer period? I appreciate the fact that you shared why you would want a shorter time period. But for perspective, any significant shorter timeline could create market disruption, but particularly given the large exposure of the retirement funds and institutional investor to securities. As you rightfully mentioned, I really resonate with the analogy of a lot of people, holding retirement funds. So as we respect national security, but we cannot have, people from different countries who hold securities and pensions go to waste, something which they're investing in. Secondly, one thing which we would like to bring into notice here is the element of a delimitation fee. Delimitation fee, which I believe MNT shall take the responsibility for. So based on internal estimates of market disruption and administrative cost, we believe that the block should at least pay 800 to 900 million as a delisting fees across these three jurisdictions. So while we are amicable to providing a larger timeline which GIF is talking about, and we can discuss delimitation in phased manners, in three phases of three companies each, in months which we can discuss. But I believe we need to put across the element of the delimitation.
So among all these options we have just discussed, which of the options discussed here today best balances regulatory integrity and investor protection? What do you think?
Actually, Madam Mediator, I just wanted to re-emphasize the fact to both SECC and to GIF that, the 26-month transition period that was wanted by our government, the RIB government, was actually something that we have to strictly adhere to, simply because my client here is most concerned about the financial position of all the corporate entities that are within the block itself. And specifically, if we are not able to adhere to this 36-month transition period, my client here will incur severe penalties, which include monetary fines, restrictions of foreign currency. And this would ultimately impact my client's business as a major energy sector. Perhaps Jordan can further elaborate on this.
Maybe to provide some clarifications, the reason why we're looking at a shorter delisting period is not because we want to, but we really have to work within the 36 months that our government has given us concession to. If we do not stay within these 36 months, we are facing significant penalties. But what I hear from both SECC and GIIF is that you're open to a structured transition. And GIIF, I understand that ultimately you want to protect your shareholders. Now, I have a proposal and I want to hear your thoughts about this. I am asking for 21 months SECC because I need to protect my financial interests. But I hear that the timeline extension is important to both SECC and GIIF. And I can work within 36 months. Now, if I am willing to go up to 9 months under this structured transition of 3 companies in 9 months, the next 3 companies in 9 months, and the last 3 companies in 9 months, is this something that is doable? And I will address both your interests in time. So GIIF, I hear that you asked for a buyback. Now, unfortunately, our finances are tight, and we are unable to offer a buyback. But I hear that you are looking for some form of compensation, and we are open to discuss this with SECC as well under your cooperation. At SECC, you also mentioned some form of delisting charges, and you mentioned a number of 800 to 900 million. Madam Mediator, I feel like it's a little bit premature for the 800 and 900 million at this stage, but I can put a pin on this first, because I would like to first understand from SECC why you're asking for this sum of money. And from what I understand, for the delisting of these companies, it is usually $300 million. If we are giving you an extension of time, which means that we have lesser time to move into our markets and recover our finances, we would be unable to pay such a high sum. So is timeline more important to you, or is this delisting cost more important to you, so that we can balance this with our operational sustainability as well?
Can we think about generating more options? Because we are in a loop. So what about alternative audit inspection or regulatory oversight mechanisms future listing structures, a temporary trading window we have already discussed, depository receipts, conversion mechanisms, restricted trading segment, escrow-based or regulated supervised audit disclosure amendments, phased delisting already we have talked about, and structured buyback program or investor liquidity facility. So out of these,
if I could add just to that list about how it has actually played out in the real world in the past and how what we can take away from this. And this is just a suggestion to the SECC and MNT to explore, again, taking home the point of ultimately protecting investors. So when a similar situation arose between the United States and China, where China, equivalent to BRIC, had introduced similar situation and similar laws, what the governments agreed upon was a kind of a audit mechanism that Madam Mediator pointed us to. In this, and we enacted this, they had some kind of an inspection at a neutral venue. This is a closed venue, they chose Hong Kong, we could agree to another neutral venue here, where audit inspection happens by the SECC and their representatives of the Libyan bloc. If we are able to agree to this, I request the MNT and I urge them to please consider increasing this window of delisting. 27 months, which you have proposed right now, is still very less. We would urge you to go back to 36. That is the minimum that the investors require with some kind of safeguards.
And I would also like to get some clarification on why the government has imposed the 36 months timeline, because from what I understand, the government of BRIC is not the one which is trying to delist the companies, right? Their act does not require delisting. In fact, their act only prohibits information. So I'm unsure what they are imposing the deadlines for, if you could just clarify.
So GRIF, both Tyler and New Council, if I can just clarify a few things that you have asked. Now, I believe the first thing that you have asked about is with regards to the timeline. And also, I understand that you need to protect your shareholders' interests. So, like I mentioned earlier, I'm willing to protect your shareholders' interests, and it's important to me as well, and for your confidence in our market. But for me to promise any form of compensation, this is something that I will need to discuss with SECC as well. And like I mentioned, my finances are tied to the phase timeline that we're talking about. Now, the 36 months to answer your council's question is given to us because, as we said, we really went to the government to try and protest against this particular audit inspection. And we are open to also alternative audit measures, but our firm position from the government is that we cannot give our audits to foreign governments or anyone related to foreign governments. And if SECC, you can find an alternative way for these audits to proceed, we are willing to listen to you on that. GIF, with regards to the 36 months that you are asking about, this is because, as my counsel earlier mentioned, it is the emergency ordinance that the government has granted us, which is a leeway for us to slowly delist our markets. Because if we exit right now with their regulations, they also understand that this would crash the entire markets in the global world. And this is also why the government has offered us this concession, but we are unable to go beyond this. I hear that you are asking for 12 months, 12 months, and 12 months, right? But in return for this, I would need to also care for my finances, because with the increased timeline, as I mentioned to SECC, I would have lesser finances. So if SECC, if I offer 12 months, 12 months, and 12 months for three companies, and three companies, as GIF mentioned, are you also able to meet my financial interest in terms of reducing the sum that you have asked for the delisting, especially when the market rate is $300 million? If you would like, I can raise a number for you as well to get a better picture on this.
Yes, thank you so much, George. I believe I like to, since a lot of backward and forth just took place, we'd like to clarify in this
do you want to go for a office?
I think if we deem appropriate, we'll take.
Because this is interdependable situation. What else in the caucus if you want, we can go in for a caucus.
Right, Madam Mediator, because even their concerns are valid. But I believe GIF will also agree with us that we are giving a timeline of 44 to 45 months to ensure orderly investor exits, gradual index rebalancing, and sufficient time for market participants to actually adjust their portfolio.
Because nobody wants a sudden market disruption,
right.
An erosion of share values of the investors, like what GIF was speaking. So what if you really want to collaborate what should be the points to be harping on in this mediation, so that, because we are not feeling towards a settlement right today, but how we can take it forward, the pathways ahead.
So, Madam Mediator, if you may. So, first of all, what we have identified, I believe, is that GIF, you obviously want a timeline which supports, your investors to take an exit. Additionally, you want some sort of buyback. With regards to the buyback, we concur with you, and we would, really encourage MNT to, support this buyback, because we think that this would, as a regulated block, as a big block in the country of RIV, we believe if they initiate a buyback, it would set a very nice precedent also. So we concur with regards to the buyback. And answering your concerns with regards to the delimitation fee, I completely agree with you that it is generally approximately, I believe,
But here I think, sorry to interrupt, what about the buyback will be, affecting them?
Thank you for raising that. And I've also mentioned to GIF that a buyback is not feasible with our current financial position. However, we come here to collaborate.
So it is not possible, we can go into a converging point, what are the converging points and what are the things we should work upon?
Maybe I can answer that question. So we understand that we have a strict timeline of 36 months, and I'm willing to go through this extent of 36 months. If we can collaborate with SECC to protect our finances as well, this would also align with GIF's interest in having more time for their investors. At SECC, what I require from you, if I give a longer duration, which I believe you were also asking for earlier as well, is to protect my financial interest in terms of reducing the delisting cost, because I will have lesser time for me to move into the other markets as well. And my finances, as you know, have crashed in the SECC markets. This is not something that we are unwilling to give, but we are unable to give given our financial position. And
I think that answers your question also at the end.
Madam, I sympathize with the situation here, because I can understand that the cash flow positions are tight, liquidity is even tighter for them. So if we are able to raise it till 36 months, we are willing to relax the situation on buybacks, provided the compensation arrangement that you had talked about, we can get into numbers. But we still want some kind of compensation. I think Shruti was mentioning to me that we can also try to do this in a tripartite way in which the delisting fees, which we could add to that.
Yeah, I want to confirm with SEC that the delisting fee that you're asking for, would that be put towards any investor protection measure? So, for instance, maybe that could be put towards converting this into depository receipts, and that could solve some of our problems possibly. So, is that something you're open to?
Actually, for SECC first, perhaps Jordan, I think you did share with me before that you did have some reputational concerns, and also with regards to investor assurances, that you do not want to lose any investor confidence because you plan to go to other foreign jurisdictions for exchanges. So perhaps you have any other solution with regards to, apart from the buyback scheme, since we are not open to that.
Thank you, Kavi. It's not that we're not open to the buyback scheme, but our finances are tight. And I hear GIF, you mentioned about having compensation. And as I said earlier, this is something that we're willing to collaborate on to protect your investor interest as well. If SECC can guide us through this as well, because SECC, you mentioned that you wanted to balance operational stability in the market as well as investor. So we really need your help as well while balancing the investors' confidence to help us with our financial situation. And also, I believe GIF has earlier mentioned about whether the delisting cost would be completely imposed on us as well. And I would also like to find out the same.
Yeah.
And does the buyback really helps? I mean, in one exchange you do that, it has cascading effect, eroding your investors' share, isn't it?
Madam Mediator, the entire plan initially was to ensure a buyback which is structured, it is in a pro rata format, etc. But looking at what we've heard from NLT today is that it is not possible for them. And here, of course, I do not represent any personal interest.
You have to think about your investors also.
Right. So my investors would.
So it is not this thing. I mean, island that you are buybacking there and buying back there, and it is not having any reputations.
So, Madam Mediator, firstly, with regards to the concerns about the buyback, while we encourage a buyback, because according to the internal estimates which we have had, we have seen that investors have faced increasing pressure to strengthen accountability standards from foreign listed companies. So for this, we believe if MNT is able to collaborate upon a buyback, we believe that that would set the correct precedent. Obviously, we understand your hands are tied. You giving a buyback is something which is not perhaps in the best interest. What we are willing to do is we can contribute a limited stabilization amount, with to the buyback which you are giving, but only under very strict conditions, something which we will negotiate upon.
Why not some policy mechanisms which can, fight in the market? There's a lot of noise about this. We are talking about the buybacks, this much or that much. It's only amount we are talking about. What about the policy changes, like depository receipts, I have said? We are not talking about that.
Also, I understand the investors part that SECC and GIF is committed to protect. And I've also shared ways on how we can identify a shared compensation mechanism if SECC is open to that. But I'm feeling quite disappointed because I have a financial interest to protect as well. And I just really hope that SECC can balance that together with me, especially if we were to increase the timeline that I've already agreed upon.
And he already said about that alternative inspection, like Hong Kong. Why not think about that?
Another mediator, because you are
you are seems to be fixated on the minus of the negatives of the buyback, and you are asking the buybacks, but it won't solve the.
Yes.
Madam, if we just may. So from what we see as SECC is that we can do our best to help both of these parties here, MND and GIF. I think one thing which at this juncture, if you make here, will be great is with regards to the delimitation fee. Since you seek certain help from us with regards to the delimitation fee, and your financial interests are tied, I think after conferring with my counsel, firstly, I'd like to explain why it's not 300, it's not the conventional 300 million, and why we actually are, demanding for an 800 to 900 million amount. Please rest assured that our intention behind this demand is not to penalize you, is not to, seek any profit, and answering your concern as well. Of course, the amount that we are demanding as the delimitation fee would also be put into, apart from administrative reasons, into compliance, into ensuring better security for investors as well. What the problem here is the extraordinary nature of this present situation and the systemic market disruption which has been expected from such deals. So I think all parties will appreciate that in such a scenario, such major delisting across 3 countries which we represent in this as the SECC will be very difficult for us to do. Which is why in the non-conventional amount of 300 million. But still, in the spirit of collaboration, we are willing to go down on this amount. However, that is preconditioned on the fact that we, see some sort of collaboration from MNT with regards to the compensation structure. We have already offered you that we are willing to offer some amount of compensation along with you in a stabilization package. But however, with regards to the delimitation fee as well as perhaps a buyback which they were demanding, or certain other measures which you can, ensure to them or to us for actually ensuring that investors who currently hold securities in your country, in your block, are actually secure.
Could we go into the negotiation, the points which can be negotiated, which are not possible, you have heard each other. But the negotiation on which are the points on that?
Earlier you mentioned about alternatives that we can
Be
use.
short because we don't have
I
time.
understand. And it seems like we're also moving towards the delistment cost. Now, on our end, we have given leeway for the timeline that the parties
So
have
we are not
provided.
repeating the timeline. What are the negotiating points in the?
I think the things we have heard movement on and the agency agreement on is first the timeline, because I think 26 months is something that I've heard from all 3 tables that is amenable to us. So that's the first point I would like both the parties to consider. Second, and I should use just briefing me, I think they're not very hell bent from getting buybacks. Right? Buybacks, as I'm mediator has pointed out, perhaps does not help all sorts of investors. Right? Instead, we just want some kind of financial cushioning, whether it comes in the form of a buyback or in the form of compensation. The third thing that can be agreed upon is the delisting fee. Now, the delisting fee is, of course, a direct negotiation that has to happen between NNT and the SECC. But our interest that we hope to be protected if we have heard SEC say that they can reduce the delisting fee, but the amount that they will be giving you will be for a stabilization fund. And that stabilization fund, we urge you to protect the investors, either initiate buyback or go for compensation. So if you could structure this for us and perhaps just for you.
Yes, so firstly, it's a 36-month timeline for delisting. Out of which I think we've broadly agreed that this is going to be phased, with three companies delisting every 12 months. That will come to a total of 36 months. Apart from that, issues to be discussed are of course compensation and then the delisting.
So we can talk about the timeline and the compensation.
Right.
And Madam Mediator, I think the three issues are interlinked, which is why we have been discussing this as well. On our end, we are open to the compensation mechanism, but that's contingent upon the delisting fees that SECC is asking for. And SECC has also mentioned, right, that you are able to reduce the delisting fund for the compensation mechanism. However, the amounts that we're able to pay for compensation and the delisting is also contingent upon the timeline that we've given. And as I've mentioned, it's because the shorter the timeline, the lesser funds, the longer the timeline, the lesser funds we have to work with, because our market is unable to recover within that short period of time. Now, I've given the concession of 36 months to collaborate because I understand from SECC and GIIF that it's important for you to get a longer time, and I've maximized the time that I can give you. But in return, my finances are now short, and therefore it impacts the amount that I can provide for the delisting funds. But what I can do with you, SECC, is that if I can offer you the delisting funds, and I heard that earlier you mentioned you can reduce the amount that you originally stated of 800 million. If I can pay you 500 million for the delisting fee, but in return, because I'm paying you a sum from the finances that I have, could I work with you on a compensation that addresses GIIF's interest to protect their investments and also the compensation for a 60 and 40% ratio, with 60% borne by SECC and 40% borne by MNT? Is this something SECC is open to that will also meet GIIF's interest?
Madam, we need to just get clarification on the amount that we're talking about. So till now, we
And how much it will affect you or support your investors?
Absolutely. So the number we are looking at is 800 million US dollars. That is the fund that we expect.
Negotiable.
Correct. That is the negotiable aspect of it that has to go to our investors as compensation. Now, to be very frank, whether it comes from MNT or some kind of joint arrangement between the SECC or the MNT, the investors do not care till the time they are giving this cushion. So we would urge you to implore how this financing is met and we can reach the number of 800 million.
Yes, and GIF, I hear that you mentioned the sum. So SECC, I propose that whether we can work on an arrangement on this with 60% borne by you and 40% borne by me. And in return, I will give you the delisting fee that you're asking for, 500 million, which is maximizing my current financial position as well.
Madam Mediator, if we may just seek clarification. So, what MNT is proposing with regards to the 800 million separately asked by them, are they asking us to bear 60% cost of the 800 million potentially, having them pay us the delisting fee, also contribute to a compensation fund which we proposed the compensation fund will be 60% of 800 million, and then have you pay us the delimitation fee as well.
Yes. So GIF has asked for $800 million, and I would also want to understand why you're seeking $800 million. Specifically what this will be used for, especially with the extension of time granted for your investors to exit safely. And SECC, to respond to your query, you have also asked about the 60 and 40% splits. So what I'm saying is, I can meet your interest in terms of the delisting funds, and I'm going to pay $500 million. But in return, could you also help me protect my financial interest in terms of increasing the composition of how we're going to pay GIIF the amount they want to a 60% SECC and 40% MNT splits?
Madam Mediator, I think we should take this question. So, as a matter of regulatory principle, we like to give
your interest is paramount.
Absolutely. Yes.
So we'll also have to explain where we are coming from with regards to compensation. I think we're quite disappointed with regards to the 60-40 structure being proposed, because as a regulatory authority, making contribution towards any compensation is extremely difficult for us. We cannot establish, a president of regulators contributing.
Is it possible compensating with some policy change or something like that, or the restrictions are not?
Getting to that.
So that they also have some headwind.
We believe that, first of all, with regards to GIF, I think question asked by MND was relevant, that if it is, can they explain the rationale behind the 800 billion amount and come down on it? Secondly, we do not believe that 60% of that amount which GIF demands is plausible for us to give. We want the maximum amount which we can quote.
I see it this way, like if there is a policy change or something like that, it will definitely go a long way. This is not the one-off case. Again, this kind of thing can come up. But if the policy change, it will definitely give a much more value to the GIF, the investors.
Madam Mediator, if I can focus on the positives of what we are raising currently, because I realize that we've been talking a lot about the negatives of the situation, but we come here to collaborate. So maybe I can explain the positives of what I have raised earlier on. Now, I understand SECC that we need to balance market stability and the investors' interest, right? If we are able to come together in terms of that split that I proposed, we can protect the investors' interest and share.
Will not be the 60-40.
Well, mediator, I prefer both parties, and I would like to propose a solution which I believe will be mutually amicable. First, why we want 800 million? We want 800 million as
No, don't want the amount. I mean that it is the amount, buyback and all these things are very, I mean, it is not permanent in nature.
No, Madam Operator, this is a combined solution that I am presenting. Right now, we need some kind of liquidity infusion, which is absolutely important for us. We can reduce from 800 to 500, provided there is some kind of structural guarantees that are given. To explain this structural guarantee, which the SEC will have to work towards, is forward depository receipt. This depository receipt will look as follows. We will take shares that are currently frozen and then convert. These could be given to an investment bank. This investment bank could be, let's say, situated in the United States of America. They purchase they hold these shares, convert them into depository receipts, and list them at the NYSE or the NASDAQ, where all these investors can still continue trading them. But that being said, I think this should be on board, doesn't conflict with anyone's interest, but at the same time, we will want some kind of liquidity infusion.
Also, to clarify how these depository receipts can be beneficial for everyone, is that currently, even with the extended timeline, the issue that we face is that even though we are investors willing to sell these shares, there is probably no one willing to buy them. We are also not able to buy back, the share prices have fallen drastically, which is why depository receipts, which list these depository receipts on foreign exchanges, that will allow demand to be
There
created.
has to be a policy restructuring from SECC.
Yes.
Please think about it. And I don't think it will help MNP as well, because this is where you will be in the market now. So they are also there. So it should be a long-term solution, not the one which we are having at hand right now. That's how I see it.
If you could lower the depository receipts aspect of it first and kind of close on that, after that moving to what kind
That
of.
is a normal procedure, if I'm.
No, I mean, absolutely good. Yes.
It can be.
Madam Mediator, we're open to the exploration of the depository, and actually I think that if
SECC, what do you say?
Yes, so with regards to depository, so basically we're talking about, some sort of defreezing arrangement through depository receipt. So while
It gives us a strong positive signal to the market.
yes, this is something which we are.
Somehow you want the market to come up.
Yes.
If it goes down, everybody goes down. So.
Madam Mediator and parties agree that we are open to this defreezing at the China country.
So with regards to defreezing, obviously we have also assessed the impact, and Madam Mediator, we concur. Obviously, we also want the market to regain its pace. So this is something which we are amicable to, but would require negotiation upon the timeline for the same, with regard also MNT, answering our concerns with regards to the policy structuring. Additionally, when you, Madam Mediator, talk about policy changes.
No, I mean, both parties be willing to explore a working group of technical consultation to refine the options discussed today, not going into again the same hole of buyback and.
Well, we can appoint a structural committee which looks into this aspect of and the depository receipts, and they will take care of all the concerns SECC has mentioned, such as timeline, etc. All of this can sort of have representatives of our own and also talk to our governments to ensure that
an agreement to that proposal.
I think that my client might think that would be a feasible solution. I think one concern my client would have with regards to the structural committee, who will consist of this structural committee? Is it just GIF, SECC, and MNC altogether, or just one party only?
It will be a joint block, is what we're suggesting, Madam Mediator, because this is a jointly agreed solution and would require perspectives from all different expert areas. So we suggest that it is a joint board, but we also want investors to have some place.
Yeah, and we can also have some independent experts in the area appointed to it. I think that is more important for all of us. Some independent experts can also assess the options.
I think I see agreement on both sides. Yes. Madam Mediator, to some extent, if I may, we also have a consensus with regards to this, but we would still want SECs.
Until that time, don't come with your freezing and all these kind of, it can be kept at abeyance.
Just a clarification, Madam Mediator. So by the time the defreezing is happening, we do not do any delisting. Is that what?
Obviously, otherwise, what is the point? Like whenever we mediate a case, the court there also is the status quo, unless and until the mediation finishes. Fix a timeline, go through these options, and then you can come up.
Madam Mediator, since we have agreed on the depository receipt, I urge you to present the solution of the 36-month delisting window. I think this 36-month is the window within which depository receipts will be made. And second, you can.
Okay.
Actually, you mentioned about having a long-term solution. I understand. I just have one proposal in terms of long-term solution that we can.
We have to be negotiated between. Yes. I was giving you what if you can use this and that.
Yes.
But these things, it is already there on the table now. You three have to decide.
Yes, and actually. Thank you, Madam Mediator. I wanted to mention in terms of the long-term solution that I think will also help all of our interests is if MNP can also move towards the other markets, and that will also allow the investors to get what they are funding for. And SECC, that will also help to balance the market stability. In light of the decreasement, I think that's a possible long-term solution that we can work towards, especially if the regulatory compliance is an issue. And in the long run, this will Yes.
Okay, so Madam Mediator, and I think we understand where you're coming from. Firstly, talking about the defreezing arrangements, that is something which we're certainly amicable to. Conditioned on the fact that we actually agree on a some suitable timeline for this. However, one thing which currently we cannot agree to is that we do not do any delisting during this time.
We cannot do, I don't think so.
But isn't 44 months that you had initially suggested, we brought it down to 36 months. 36 months will be a deadline for this structured committee that we've talked about, including independent experts, to ensure that the American depository receipts are made, some liquidity is generated in the market. Meanwhile, in those 36 months, MNT can explore listing in other jurisdictions outside the three jurisdictions that SECC represents, which will give us a little more liquidity. Is 36 months okay? Both is a timeline for the depository receipts to be made, and also only after which delisting will begin.
I think that is something which we can obviously discuss, but that is preconditioned on the fact that actually delimitation is something, or delisting. Thank you so much. Delisting is something which we can discuss because our interests as a regulatory authority are not really being, kept in mind here. What we believe is, if Madam Mediator would like to add something to that.
Yeah, I thought that the reason was actually already agreed by SECC with regards for both GRIF and for MNT. So could you help clarify the situation for all of us here? What exactly is being said so far in the session? And
You have to come up with your, this thing, 2 minutes each.
So, Madam Mediator, we are agreeable to the committee that was proposed, and we think that will help in terms of the long-term solution. But if we are being put back to the delisting fees, then it's as though we are delisting the stocks, and it's not what we all want today. So what we are asking from SCCC, and I believe that this is in line with the investors' interest as well, is for alternative solutions for the defreezement so that we don't have to face the dire delistments that we are trying to avoid. At the same time, MNT can also look towards going to other markets that will help secure the
That has been
investors'
discussed,
funding.
we have already
Yes.
discussed SCCC and we are here last.
Madam Mediator, I'll keep it short. We are very much on board in any measure that helps improve liquidity and prevents market erosion. Creating depository
Regulators.
Creating depository receipts is one such option. The second option is for you to get listed elsewhere. However, this does not mean that investors will still not face any trouble. Even if they are asked to trade in American depository receipts, that is very difficult still for them because each country where they are situated have their own guidelines and own reserve bank policies on how much can be invested abroad. Therefore, I understand great time is short, but we implore the Rivian block to explore options of compensation that may be given. We have come down to an amount of 500 million, and again, delisting fees and this compensation can be talked about together if we were to get into some negotiation on a later date.
Madam Mediator, we are more than amenable to actually parking the defeasement and agreeing to it, but we believe
Some
that
kind of escrow account can be created and do this.
we believe
Can be done.
if it's okay, we believe that leaving this to further negotiation, we are amicable to discussing defeasing arrangements. We really appreciate the solutions which you have come across with. Maybe discuss the timeline for the same. But as GIF also mentioned, perhaps it would be better if you could park it and discuss the delistment fee as well as the compensation which would be provided.
What kind of a joint message should go to the market? All three of you. It has to be a joint message. You have to think about it. What kind of a joint message must go to the market?
So, Madam Mediator, for us as SCCC, the kind of solutions which we have proposed, we see the actual message to the market going is, if they agree to what we are proposing, we see the market receiving actual assurances about compliance. We see the market, we see the Rivian block setting up precedent in the history of securities as well.
So can we point out 1, 2, 3?
Madam Mediator, yes, I believe firstly, it is that the regulators care for the company. I believe the message that we need to send today from this mediation and why we're here is firstly that the regulators care about the companies that are listed on their stock market. Secondly, and also the investors' confidence. I think that's most important today.
I believe that the president being set, investor confidence being restored, compliance and national security being something which SECC and we together present as something which we all mutually respect, and of course domestic investors' interests.
And most importantly, we should tell the market out there that we are today exploring options. That the SECC is not closed-minded, that MNT is not bound by the Indian authorities. Absolutely, madam. So, joint declaration showing that SEC is not closed-minded, because always the problem with the investors is that the stock exchange will have problems, the government will have problems. That is what we must clarify, that we do not have problems. We are exploring options to increase liquidity, to minimize disruptions, and to minimize any loss of value, both for the companies as well as for the investors.
And also in the future. I just want to say for both present and also in the future, I think that's an important message to send that we are forward-looking.
Absolutely. And this is nothing, I didn't know, fraud played or something like that, because the moment it is delisting or something like that, immediately it comes to the market mind that something is going on. So, now that this is the thing and you have already agreed for a working group of technical consultants or an expert putting therein, thank you for the clarity. You all have brought to the concerns and constraints involved. It means we now have a clearer understanding of what the key risks and interests are in the long-term view. Correct. Perhaps this is a good moment to shift our focus towards exploring possible pathways that could address those concerns while protecting the interests of all sides. Even if we cannot resolve everything today, establishing a credible pathway forward would be a meaningful outcome. Given these constraints, I would like to place a possible pathway on the table for your consideration. This is the what is more it is just for the discussion next time or within yourselves. What if SECC could consider allowing a time-bound transitional trading window with enhanced disclosure, giving investors a fair opportunity to and adjust and exit positions in an orderly manner, during which time the parties would work toward a depository conversion mechanism, enabling existing shareholders to convert their holdings into instruments linked to trading on an approved exchange, which you have said, where compliance with applicable legal framework can be maintained. As we come to the close of today's mediation session, I would like to thank all parties for the constructive and thoughtful way in which you have engaged in this process. You have each taken the time to clearly express your perspectives, your concerns, and the interests that lie beneath them. Over the course of our discussion, we have identified several important areas of understanding as well as some issues that may still require further reflection and dialogue. Like that deposit, okay? So, what is encouraging is the willingness shown by all sides to explore practical pathways and to listen carefully to one another. That's the last point. Mediation often works in stages. Sometimes progress is measured not only by immediate agreement, but by the clarity that emerges about what matters most to each part and what solutions may realistically move the situation forward, both from a short period time and a long term view. I encourage all the parties to continue reflecting on the options discussed today and the areas where common ground appears possible. The ideas generated here may serve as a useful foundation for further discussion, whether within this forum or through your respective advisors. Thank you again for the professionalism, patience, and openness you have demonstrated during this session. It has been a privilege to assist you in this dialogue. Unless there are any final comments from either side or sides, we will now formally conclude today's mediation session. Any final comments from one?
I'm very heartened that we've come here today with an open-minded approach and also for the exploration of the potential of how we can balance both investors' confidence and their compensation requirements, as well as MND's and our block's interests. And I believe that together we can find a future solution that can send a message to the markets to show that we care about the markets, we care about the companies, and we care about our investors through different solutions that we can explore together.
Thank you, Madam Mediator, for mediating this so well. Thank you so much for all both the parties to come on to the table, especially SECC, to show the willingness and the openness to protect investors' interests. And I am glad that the note I started on with, which is that both of you have an obligation and legal responsibility towards investors and shareholders respectively, was taken care of. We have some homework to do today. We have to go back to our respective boards, our respective regulators, and talk about how we can mechanize this to both policy solutions and to company-led solutions, whether it be compensation or timely buybacks. I urge the parties to take this in the essence of time, because time is of importance here, and we need soon with these goals in mind. Thank you so much.
Indeed, Madam Media, I believe that it was a fruitful mediation session. Initially, I thought that these things would have become inevitable.
As long as you give them some time. Relisting is okay. Obviously, you cannot, go without that. But yes.
Right, Madam Media. Also, I'm very glad to see how the compliance mechanism regarding the decreasing part has come into play now, and that rightfully mentioned by GIF that we have some homework to do now. I believe that it was a great session, and I'm grateful to be here.
I think we have put it in a very, nuanced manner. I think some things which we weren't expecting, like, GIF would come with such creative solutions. We are really happy that, they have explored such options. We also saw a certain amount of good faith on your part, the fact that you are also cooperating with talking to your own government. We're really happy with that. As Jake said, obviously we have certain homework to do. We believe there are certain priorities which we have, which we will also look into further. But I'm really grateful to you, Madam Mediator, for mediating this.
Thank you everybody for this coming to this mediation, and I hope that this will give you a future points of discussion and conversation. Thank you.
Thank you.
Thank you.
Since we will now be having the reflection session, I request Madam Mediator to please come out here.
Yeah.
Okay.
Okay, thank you very much. In fact, it was not an easy subject to talk about, and you people did a wonderful job. I mean, thank you. I mean, we really loved it. Now, here we have some of us who are really specializing in this subject. Probably they have certain reflections. I'd like to invite them to share their reflections with you on the subject.
So, if you guys can, as I speak for everyone, what was your strategy? Like, what were your respective strategies that would give us some perspective? We can start in any random order. I guess GIF was most clear, but like MNT, SECC, what were your strategies? What were you thinking?
Maybe
you
I
can
can
address all of us. Like.
Yeah. So to the dear judges here, maybe I can explain what our strategy was coming in. So first of all, from our aspects, we wanted to avoid delisments, but we understand that we also have to maintain the regulations set by the International Forum. So when the mediator mentioned about alternatives, we are open to it if we were able to work around the auditing that our government has imposed. We understand as well that we wanted to discuss the timeline if delisment was really an inevitable consequence. And therefore, when we approached the table today, we found that they had three interests in mind. The first is we needed to protect our finances. The second is also our relational interests with our investors, because if our investors are gone, we have nothing to work with as well. So when we came to timeline, and I think we focused a lot on the delisment at the start, we wanted to collaborate in terms of the timeline. We heard from both parties that timeline was important to them for a safety exit for the investors. And so we were willing to give up to the 36 months that was given to us. Originally, we wanted to go from 21 to 27 to 32, and we even went all the way up to 36 because it was important to them. In return, I wanted to get my financial interest, and this comes in two forms. First of all, the delisment fee that SECC is asking for, and second, in terms of the compensation that GIIF is looking for. So that's why when I mentioned that I agreed for a higher timeline, I mentioned to SECC whether they could meet my financial interest in lowering the delisment fee, especially because 300 is the usual market price. And in terms of the compensation, if they were unwilling to meet me in the delisment fees, then I will require a higher shared arrangement for the compensation with more contributed from SECC. And if my counsel has anything to add on this, that was the strategy that we came in with.
So with regards to our strategy, we had expected some sort of, since we were taking the regulator's position here, we understood as we already reflected in an opening speech, we had expected that, as the people who are enforcing regulation, we would have to begin with, an amicable role in this resolution. So our settlement mechanism was that, all right, we will obviously enforce compliance on them, and we found out that both of the parties were okay with delisting. So our priorities was to talk about a delistment, support investor confidence, because our confidential information had clearly told us that, enforcing that there's an internal impact study which talks about how we cannot just do delistment of companies prima facie and just, okay, you cannot participate anymore. We had to give them an extended timeline, especially with regards to GIF's interest, which is why we began with the 44-month timeline, and we were also allowed to go to around our lower limit was around 36 to 37 months, which we also went to because both the parties were also exploring those solutions. To us, why we were again and again reiterating on the delisting fee is because our confidential information as well told us how 300 million is not going to be an appropriate amount in this scenario, how ensuring compliance is going to become very difficult for you, so you must talk about a higher delistment fee. Obviously, when we began with 800 million, we were willing to go down on it. I believe if there would have been more time, we would have discussed those numbers, crunched those numbers more. Additionally, with regards to the compensation, so our initial strategy was to actually help GIF to press on the buyback mechanism, because what to us had been revealed is that GIF is going to demand a buyback and they need a buyback. So we had thought that our strategy would be, okay, we back you with the buyback, we'll get you buyback, and additionally to help MNT, we'll give them compensation as well, because a buyback in these scenarios is obviously going to be very difficult for them, as well as any compensation. However, what we found, what we had to adapt in the round is because GIF was not that insistent on a buyback. So what we had to explore was perhaps maybe new compensation mechanisms. We didn't really go into the numbers, but we agreed to a compensation structure where we would have gone, around up to the extent of 50 million. Okay, we can help MNT. And obviously, our strategy in the beginning was to seek assurances. The biggest was to seek assurances from them that, okay, your government is helping you, which is why we, in the information gathering, our intention was to ask them questions. Okay, is your government helping you? Since they are a major bloc, they have a bargaining power in front of their own government. Additionally, defreezing, even though we didn't talk about it much in the beginning, but we were still, our confidential information allowed us to talk about defreezing mechanisms. However, as we tried, we were trying to park that discussion. However, that is something which was beyond our control because we weren't really allowed to talk about defreezing a lot. It was just 2 lines in our confidential information that prior to further negotiations, but you are unable to defreeze it, which is why we didn't really do that. Thank you so much.
Yes, I'll be brief. So our interests were very clear from the beginning that we to protect investors. This took 2 shapes. First was liquidity, and second was to minimize losses in any falling shareholder value. Now, just with the confidential information in terms of our preparation that we had, our strategy was to start discussion on the delay of delisting. Our interest was to delay it as much as possible so that we have a greater trading window. But we thought that we will sort of leverage this discussion. So our numbers were 42 to 36. So we would have started with 42 months, and we could have agreed to a lower number, but for that we would have leveraged a buyback. The logic being that I can agree to a shorter window of delisting, provided that you give me a certain sort of a guarantee that there will be buyers for this. And who can be a better buyer than the company itself? Plus, whenever a buyback is introduced, the shareholders, the share prices naturally rise wherever there is an announcement because there's a time period. So this would have also helped us with the second issue, which is to minimize losses. However, when we came to the round, we realized that there's a lot more confusion and there was a push even from the mediator to look for more structural solutions. We realized that structural solutions were any day better than what is there in our confidential information. If we are able to agree to decreasing, that is any time better because the share prices will rise naturally, there will be more liquidity, there will be more trading, everybody will be able to exit whoever wants to exit. More innovative solutions were of course ADRs, GDRs, etc. that we tried to propose such that their interests, their positions which were initially conflicting could be brought together with combining interests.
Just a couple of other things we have discussed right before the round was one that even if we were to go for the buyback, we would have then pressed for buyback at a fair price, and we would have perhaps asked SECC to intervene there because at the current prices they've already fallen quite a bit, so we would have wanted that at fair price. And secondly, to also find some way to use the delisting fee for investor protection. This is also something that we ended up asking them, and they also seemed amenable.
Dear judges, if I can add one thing as well. From our position in our confidential information, we noted two things that we couldn't compromise on. The first being the 36 months, and also in line with the government restrictions, which is where we cannot provide the audits. And second, in terms of the buyback system, which is why when we heard from GIF on the buyback, we were willing to provide some form of compensation that we wanted to work with SECC on. But ultimately, our three interests was the timeline, the delistment cost, and also the compensation, of which the other two hindered was the contingent upon the timeline, because if we had a shorter timeline to work with, we can recover our finances more by moving into other markets. But if we extended, which we did to 36 months, then we will have lesser liquidity in terms of our finances because we are unable to shift to the other markets in time.
So let's get the experts now on how this thing.
What? So just to understand, I know that all of you kind of came to the same page on ADRs and GDRs. But can I understand fundamentally GIF, how would an ADR solve this purpose right now?
So, because first we come to the preliminary understanding, but I'll try to explain whatever I know and I understand. So the idea of an ADR, let's talk about a GDR, is about an American company, for example, trying to list in India, where it cannot directly list. What an Indian investment banker can do, an investment bank can take these shares from that American company, convert them into GDR. So 5 shares will result in 1 GDR, and that GDR can be listed in the Indian market. Now, our creative input here was that these shares, which are perhaps frozen in their accounts, could be converted into GDRs, and those GDRs can be listed. I understand that there's a problem. Sorry. We are not the investment bank, so we would have. Right.
In this court management mediation, how is ADR a solution? Did you have an investment bank here that could potentially take on the obligation of listing?
So we did already have a bank in place. That was something that we were hoping that we could all explore. But the reason that we think this helps our interest is that if a bank was to take this on and have GDRs listed elsewhere, then that at least creates demand for the shares.
I understand that that is not something that we had ironed out. It was also not something in our confidential information that we could have made up. But I think the solution that we ultimately reached, which was to make a joint structured committee which will take all these concerns into account, which is, for instance, the SECC's concern of the timeline, would have also perhaps logically taken this concern also as to who will facilitate, which investment bank will facilitate this kind of conversion process.
So you said that they didn't agree with it.
They didn't agree.
They didn't agree on that, and also SECC, you guys are regulators. Are you okay with setting up committees further to discuss and deliberate on this matter? Why did you agree?
Exactly. So we did. I would like to say that I don't think that in the round we actually agreed what we tried to do. Again, we reframed this as a defeasing arrangement, right? So
Let's come to the point. They made a very clear proposal of APRs, which you guys implemented. And according to the and they also proposed a committee with representatives.
Independent experts.
They identified the requirement for independent experts, etc. As a regulatory body, can I understand what your strategy or motivation was to agree to that proposal?
Ma'am, while they proposed this solution, and when we talked about it, as we previously said, our whole intention, because you are absolutely right, as regulators, we cannot just agree. So what our demand would have been, had this been negotiated, is to take operational control of any such committee if formed. So what we did in our strategy is we actually tried to park this subject to further negotiations, as you mentioned to Madam Mediator as well, is that we can explore such solution which ultimately lead to deep of assets or other solutions such as the committee they proposed. But had this been negotiated into in depth, we would have definitely demanded that even if there are independent assessors, we would be calling the shots since we are already a regulatory authority and give us the operational control of it.
And operational control of the committee in a situation where the supposed to be split constituencies of the entity which is listed with you is enough for you to exercise control? Because they will ultimately, what I understand will mean is that they will take the shares off and trade it in another stock exchange, which hurts your sentiments as a financial regulator, right? So just having mere operational flexibility may not help. I just had some specific points, and I'll go in the order. I think I'll start with you guys, maybe as already speaking. I think the first and the foremost, and again, to start with, and I think as sir mentioned, all of you did a fantastic job. It wasn't an easy case, and my partner and I understand that you guys were giving confidential information just ahead of the session, and so you had less time to prepare, but all of you did an excellent job just out of experience of the panel. A couple of things where you could have emphasized more or which would have worked in your favor. So going on to the first one, I think as a financial regulator, your strongest argument on the table, and you have to alienate yourself from the case when you are trying to argue or present. Because if you get drilled too much in the facts of the case, you will lose sight of what your broad objective is. I think first would have been that as a financial regulator, you were doing by seeking this information, or by seeking this information, you're doing exactly what any other financial regulator should do. Because that's your job. You need visibility over companies which are listed on your stock exchanges. It doesn't matter what their protectionist regime in their jurisdiction says about disclosure of information, etc. Hence your fundamental argument should have been that I am doing what I'm supposed to do, and I will and hence compensation is out of question. As a financial regulator, you don't compensate for something which you're doing legitimately, which is within your powers to ask for information of companies which are listed with you, right? So compensation should have been off the charts. There should be no discussion on that. Obviously, there should be, and again, in the interest of moving a mediation or any kind of discussion in a forum like this, of course you move and give and take, but not on your fundamentals. Don't trade on the very fundamentals. You're the only financial regulator sitting here, right? So I think that was one point. The second is on delisting fee. So I was unable to understand the connection between a relatively higher delisting fee or 800 million or 900 million that you asked sought for, versus the fact that it's going to be a huge loss to you as a board in terms of 9 companies getting delisted. So are you trying, there is no compensation to the loss that you will anyway incur with so many companies getting delisted. Are you trying to make up for that by quoting a higher number? What was the connection?
No, ma'am.
Because that wouldn't help you in any case. I think the emphasis should have been that you continue listing and let's find a middle way to do something around it.
This is something which was rather beyond our control because of our confidential information. Because what it had specifically stated is that due to the nature of this particular scenario and due to the specific administrative regulatory costs which you are about to face because of this, you cannot talk about an industry standard delisting fee. So what we have been asked is to talk about a minimum a 700 million delisting fee for to ask for from MND. So we had quoted a figure of 800, 900, and as we have mentioned, we are willing to maybe amicably come down on it. If prices was something which would have been negotiated upon, we would have come down a little bit. But I do concur that is the amount quoted was not high because we had expected it to be tied to certain other things. It is because it was a little beyond our control.
I think from your perspective, an argument that the GIS team gave, which was get to a neutral jurisdiction and share information with us, would have perhaps helped better than a higher delisting fee. Of course, I understand it was there in your brochure, so you had to bring it up. But I think the emphasis should have been on some of the other points than delisting fee. I think going to the MNT team, I think once listing is resumed for you guys, you anyway get back to trading, right? So your argument to them I just thought that your argument should have played more with GIF than with SECC, because these were the guys who were seeking a compensation. These were the guys seeking a buyback. So your loss technically, whatever would have happened to you in terms of financial or otherwise, obviously besides SECC's delisting fee, etc., was basically them. So when they were seeking a compensation from you, besides the fact that they were looking for a longer trading window, your argument should have also been that when a longer trading window is there, with no restrictions and with the freezing restrictions uplifted, they would have been able to get liquidity, which means that they're able to do. And then they're proposing for a DR, depository receipt mechanism. Then why compensation? You're getting adequately compensated. You have liquidity in the market. Go fetch it. As an investor, these are risk takers. You are not here guaranteeing something to them. It's the market fluctuation which they will have to bear the risk for, right? Are you sitting here to guarantee that they get a compensation? That means it's a lender mechanism, right? So that should have been your biggest argument to them, that there is no compensation, it's off the charts.
There was no legal basis for
a compensation. The only basis it's an equity risk, right? As a financial investor, you know what you're signing up to. There could be fluctuation in the market because of a regulatory intervention which is out of your control, right? It's a market intervention. It's a force majeure kind of an event, I would say, right? So you don't have control, so why should you compensate? So that should have been your biggest argument, your strongest argument, so to say.
Just to add to that, I think what they did successfully is that was not even a debate point. They made you all believe that from here we have all assumed that we are entitled to compensation. You should have tested the very legal validity of the
Of why compensation? Yeah, that should have been your primary argument from both and I mean, more from their side also that, when you were trying to seek a compensation from SEC, they should have just denied it. And from your perspective to them, which I didn't think there was a lot of interplay. It looked like you were collectively negotiating against the SEC, which wasn't the case. You were negotiating with them also because they were ultimately asking things of you. Yeah. And I think the third one, I interestingly assume, I think one of you guys were SEC. I think you guys said that you wanted the buyback, which was in the interest of the investors. There was no role to claim buyback. That's between the investor and the company. So whether it's in the best interest of these guys, whether it sets a great precedent in their jurisdiction, none of your business. Your role was only to regulate the market regulator, get the information of them, and get yourself off the hook with respect to delisting, whatever fee, etc., or the timelines that you were agreeing. That was just my 2 bits on on all of
It was just the interplay between two private contracts. In short, like it could have been you subjecting them to something. Sorry, you subjecting them to something as a regulator, and they I think they did a great job in terms of actually putting them under the gun than you. As in, you think you have to play the role you're playing, right? In the real world scenario, once you impose any sanctions on them, they have to comply at max. They need to convince you why it has to be less. Is the real scenario in the real world scenario is orderable. Nonetheless, great job.
Yeah. Can I just seek a clarification? I understand that you mentioned the commercial reality of how we could have mentioned that we shouldn't pay compensation, right? And we agree on that as well. And thank you for that reminder. We wanted to also check because we understand that we were talking about delisting a lot at the start. And when we talk about delisting, what we thought was that while we don't want compensation, but we also need to restore the investors' confidence. So that's why we were open to some form of compensation agreement with SECC. But I understand that this perhaps should be a point that we were more aggressive on. And
we were talking about compensation for a less than 20% share. How are you going to compensate your balance 80%? So your compensation, you are also a public listed company, right? And you also owe a duty to your own listed shareholders. So where is that money coming out of? It's coming out of the company's pocket. So, on what grounds really are you going to compensate a 20% holder?
And where is the money? That's also the fundamental point. You as a listed company will be using their own money to compensate them because that whatever money you pay them, 18% of that is their money. Correct? You understand?
It requires no response. Please hear the
it requires no response.
Just see the expert's view on it.
You could have very
makes you better.
You could have very well sort of agree to compensation, but what I think we were just trying to explain is that you had a very good legal argument to push for it. I think what they did successfully is it was a non-starter. They let you all believe that our starting position is compensation. None of you poke holes in that expectation.
Yeah, honestly, I would believe it's a flawed argument to say that you guys were liable to pay any sort of compensation. A company is not liable to pay compensation for a regulatory measure or a sanction imposed by a regulator like this.
For action that they are not responsible for.
Correct. Absolutely. Did you do something because of which you need to compensate? Did your agreement say anything that you have done some fraud or any of it like that?
And one more important thing I said, first of all, again, just reiterating, all of you guys did a fabulous job. It was a tricky proposition. It's not easy. But I think one mark which all of you missed was the negotiation. You're over here, it's a party-driven mechanism. Is between the interest-based negotiation and position-based negotiation. I thought that the entire negotiation, a large part of it, was more of the position-based in terms of the material which was provided to you. Mediation gives you a large, to that extent, room to negotiate. One, she's already halved on the point. That compensation, it was a non-starter. In fact, my first conversation which I had with one of the person who was briefing me is that why does the information memorandum even have a compensation? None of the options from your side had anything which did not require any compensation. So that seeking that compensation, I think, should have been the first thing. And second, in terms of the role of a mediator, I think all of you had legitimate arguments, a lot of things, but you were getting swayed by what the mediator was jumping onto the points. You need to stand your ground because when you choose a mediator is not a judge. a mediator does not have the subject matter experience a lot of time, and they are not supposed to. They are here to get people in a conciliatory process to get you guys to hash out your issues. So if you concede to the mediator, if you are always willing to play ball, be respectful. But be respectful of your own time, of your arguments as well, and that is something you all need to learn in terms of mediation. That's very, very important. You're not in a courtroom. You're not arguing legal briefs. You're balancing your commercial interests and thinking that the commercial interest and whatever you come to ad idem with cannot be against the public policy and needs to be put in a legal framework. Other than that, use the mediator only as a guiding sort of a thing, and you can be respectful and say that no, I don't think so, this is what we need to discuss. I think we lost a lot of time on addressing issues which all of you recognized as non-starters.
And I think the last point with GIF, in the concluding remarks, I think you mentioned that you required or you wanted SCCC to intervene for you in terms of facilitating a buyback. Again, the same point, but I don't think you require SCCC to facilitate. In fact, some of your points should also be around the agreement that you signed with these guys. If you had any kind of contract, obviously it's a listed company, so may not be some button just in terms of that, because your interface was directly with MNT and not with SCCC. So why would you want a regulator to facilitate something which is you're a shareholder directly in the company?
So these comments are not meant for any criticism, right?
Yeah.
The experts' comments are to help you on the subject, and so far as the process, how it was explained to you, will help you in future endeavors, right? So this is the whole purpose of the exercise, is to give you, so that you can, because you guys are not doing this day in and day out. In future, whenever you are, you know now how to deal with the mediator or how to deal with the process, right? The subject may be different, like all the time the problem will be different, right? But on this particular aspect, I thought this was the best comment. You are the best people here to deal with the subject, and they chose the right people here. I'm the odd man.
No, I think you guys were excellent.
Yeah, no doubt.
For like a subject that was this complex, with many moving parts and different interests that you all were talking for, I think and 60 minutes to prepare.
Yeah, very well.
Oh my God.
That's exactly right.
I request all the judges to kindly accompany me to the scoring room.
Request the participants to be
What's the clap बंद करो शूटिंग नहीं क्लैप बंद करो स्ट्रीम चालू
बंद स्ट्रीमिंग बंद है ना मनोज भाई पता नहीं यार एसीसी बंद कर देते तो निकल जाता किधर पता नहीं कहाँ कहाँ क्या है फटाफट वापस आएंगे ना माइक नहीं
भैया कॉलेज खोल के जाएंगे
नहीं यार
कुछ देख इधर ना
शट
पेन बोली अरे पेन
ये बंद करती है कौन फ्लैश बंद किया
रिकॉर्ड ना
तो हो ही जाए ना बंद रहेगा तो सेशन बंद रहेगा पूरा हाँ कुछ चलता नहीं तो बंद जगह देता हूँ।
इसका बोलेगा ना तू।